Welcome, everyone. My name is Per-Erik Eriksson, and this is once again Prata GDPR med oss, Talk GDPR with us. Today we have a few guests. We have Lorea and we have Joakim from NOYB, and we'll get back to you guys.
Yeah.
My name is Per-Erik Eriksson, and I represent Dataföreningen, or the Swedish Computer Society. This talk with us, we've been doing this for quite some years now. We started in May of 2020 with Let's Talk Security once a month. And I guess I should show you. So just bear with me a second.
I think we've been doing it for 3.5 years, almost.
We're actually doing 4 things every month. The first Thursday of each month, we do Prata säkerhet med oss. The second Thursday, we speak Excel. The third Thursday, which is today, we do GDPR. And the last Thursday, or the fourth Thursday of every month, we do the EU Cyber Resilience Act, or actually, it's today more about the new EU laws, for example, the NIS2 directive and the CRA Act. This is always online via Zoom. It's always 12 to 1300 hours. And it is currently open and there's no cost. So everyone is welcome. And you don't need to be a member of the Swedish Computer Society, but obviously, and of course, you're welcome to join us. That's about us. What we're going to do today, or before doing that, we have a few practical details. First of all, the reason we call this Prata säkerhet and Prata GDPR med oss, in other words, Let's Talk GDPR, is to send a very, very clear signal that it's okay. In fact, we want you to talk and ask questions, etc. So when you have something to say, just raise your hand and Zoom, or switch on your microphone and video, or use the chat to enter your question or comment. You don't see it, but I have 2 large screens in front of me. So on one screen, I have the video, and on the other hand, I've put the chat bar and the participant list. So I will be monitoring things and handle your questions and comments. But Joakim and Lorea, who are you? And what are we going to talk about today?
That's a great question.
And I guess I should switch off the screen sharing. So just bear with me a second. Where on earth? That's funny. Oh, there it is.
Apple computers. Can't trust.
Yeah.
Yeah.
They're really useful, but sometimes a bit of a hassle.
Well, I mean, we can start.
I'm not sharing anything right now, am I?
You're sharing everything right now.
It doesn't look like that.
Well, maybe.
Wait a minute. There it is.
Perfect.
Thank you.
Perfect. Okay. So here we are. My name is Joakim Söderberg, and I've been doing this Prata GDPR with us, for 3.5 years by now.
Yeah, well, I can
off.
tell you the exact time. We started Prata GDPR with us. We started that 19th of May 2021, so it's about 3 years.
Sounds about right. So we've been doing it for a little over 3 years, and this is the first time I'm doing it from a real office and from a different country, because now I started working at NOYB as a data protection lawyer, and I'll be doing it. I'll keep doing it, just from Vienna instead of from Uppsala. And with me today I have Lorea.
Hi, everyone. I'm Lorea Mendiguren. I'm a data protection lawyer and trainee at NOYB. And NOYB, just to give some context, it's the European Center for Digital Rights. We focus on strategic litigation that seeks to enforce provisions of the GDPR.
Yeah, professional complainers.
Professional complainers.
That's
Well, nice complainers, and you've been quite successful.
To an extent, absolutely. So the idea today is that we talk a little bit about what NOYB's been up to these last couple of weeks, especially with a focus on this Grok AI complaint that's been a big thing in the office. And subsequently, I'll be talking a little bit about an action that we're doing concerning the duty to investigate and enforce the GDPR from the data protection authorities, using the Swedish IMY as a lens, essentially, for how it works. Okay, so Lorea, the floor is yours.
So what we're starting discussing is what Joakim just called the Grok AI complaint, and this refers to Twitter. We call it, I'm going to refer to it as Twitter because the European entity is still technically the controller is called Twitter, but now we know it better as X, the new platform. Either way, we're talking about the same thing here. And Twitter has recently begun processing all of its user data to train artificial intelligence, including its Twitter artificial intelligence, which is called Grok. So I'm going to give a little bit of background on this.
Bring up the complaints.
Sure.
Or just a PR maybe.
Sure.
So we can copy.
And we do have information that is pretty descriptive about this on the NOYB website. We have some PR, and we just filed 9 complaints against Twitter for this processing of user data to train AI across multiple countries in the EU. I don't want to miss any, but Austria, Belgium, the Netherlands, Ireland, Italy, Spain, Poland, Greece, and France. So we've just filed all of those cases. This just happened last week, or this week, early this week on Monday. And to give a bit of context on what's going on in this case, on May 7th, 2024, Twitter began processing all of its user data on Twitter to train artificial intelligence. And this includes Twitter's AI called Grok, but it's also broader. It includes any AI developed by xAI, which is a separate company owned by Elon Musk that develops artificial intelligence. So this is really broad. This could be
How do we know that?
So this is stated on one of the opt-outs. I'll discuss this a little bit more in a second, but Twitter introduced, months after it began training with users' data, it introduced a default setting in its settings. And the default setting says that you give permission for Twitter to use your data to train AI and to share that data with xAI. So this is where that is stated. It's a very broad statement. xAI does pretty much all kinds of artificial intelligence training that we know of, and they've helped with other entities as well. They participated in the development of ChatGPT 3.5 and 4. So this could be potentially very broad.
But I mean, the Irish DPC through the courts have already ordered Twitter or X to do something about this, right? Why are we filing a complaint after the Irish DPC has settled with Twitter by a so-called undertaking?
So Joakim is referring to these urgency proceedings that happened before the Irish High Court last Thursday and Friday, August, 8th and 9th, I believe.
Last week.
Last week.
Yeah.
And But what happened in these proceedings, let me backtrack it a little bit to give some context. In 2023, Twitter began developing these plans to train its AI using user data. And at some point in time, they conducted a data protection impact assessment and found that there was a high risk to data subjects. So as a result, Article 36 of the GDPR was triggered, resulting in consultations with the Irish Data Protection Commission, the DPC, to figure out the best way to roll out this AI, minimizing harms to data subjects and ideally avoiding them altogether. So these consultations have been ongoing since sometime in 2023. We don't know the specifics about that. But suddenly on May 7th, Twitter began processing user data. It did not inform users that this was happening. It didn't get their consent. And as far as we know, based on the proceedings last week before the Irish High Court, it didn't tell the DPC either. So the DPC brought these urgency actions before the High Court, focused specifically on Twitter doing this processing in contravention of its consultations with the DPC under Article 36. It's a very narrow proceeding. It doesn't concern what our complaints discuss, which is the lack of a legal basis, other infringements such as the inability of data subjects to exercise their rights with regard to this processing. The DPC is focused specifically on Article 36.
Twitter and X is a public forum. Whatever I do on a public forum is going to be part of the public to partake in. What do I care if they use my posts and stuff like that for training their AI?
Well, the great thing is that if you don't care, you could just give your consent if they asked your consent. So that's the wonderful thing about consent, but they didn't use that. But part of the reason that this is vague is, first of all, it's unclear exactly what data Twitter is using to train its AI. In its privacy policy and in the default permissions setting that it created in the user settings, this just says any data on users that Twitter has. In other places,
like what?
It could be anything. So this could include public posts. This could ostensibly include something like private messages, engagement with the platform that's invisible to other users, but that Twitter can see. Really, the problem is that we don't know what this could include. It could include anything that someone does on the platform. And with regard to the public data aspect, even if this is using public data that you could argue is posted out in a forum for the world to see, when you created a Twitter account, did you think that your posts would be used to train an AI, 10, 15 years later?
Well, I haven't made any posts, but I mean, no.
So I think part of it, what it comes down to with that, and part of what we're arguing in terms of legal basis for publicly available data, is that this doesn't coincide with the expectations of the data subject. There's other aspects of the legitimate interest balancing test that we consider to be failed here, such as the necessity. Is it really necessary to use all user data to train any AI? These are extremely broad statements. But those are some of the issues that are coming up in the complaint. And just to go back to what Joakim raised before, our complaints are pretty different from these urgency proceedings that happened before the Irish High Court, because the Irish High Court is really focused on this contravention of Article 36. Now, they did come in with this undertaking to pause further training of the algorithm using EU data. But just yesterday, Twitter announced that Grok 2 beta is ready for use, which ostensibly uses all of the data that they already collected starting in May. So sure, there's no further training using EU data, but they already got it all. So
it's been done, I guess.
So this is, I mean, these are some serious issues that are coming up with this complaint.
So it's not enough, that's what you're saying.
I am saying it's not enough as of now. And I mean, hopefully with these 9 complaints that we have before DPAs, including the Irish DPC, the hope is that they're looking at these other issues that we're bringing up. And unfortunately, as far as we know, there's nothing that can be done to take out the data that's already been used to be trained. But this is where things like penalties, I think, really have to come into play to disincentivize essentially asking for forgiveness rather than permission. For 300 million users, 60 million of those being in the EU.
Cool. Yeah. We have anything more to say about this?
I guess just one last touch on this that I think might link to what looks to be a theme during this discussion. with you talking a lot about another aspect of DPA enforcement, which is inactivity and the problem there. There's something really interesting going on when there's an Article 36 proceeding. You have consultation proceedings that are really, the goal of them is when a high-risk processing has been identified, the Data Protection Authority engaging in consultations with the controller is there to try to make sure that these risks are mitigated, that data subjects are protected. And instead, what we see here is Twitter began processing the data anyway.
So to bring stuff down to the ground a little bit, when you have a high risk processing, you need to do what's called a data protection impact assessment.
No, you do it first, and that's how you find out it's high risk.
Well, you need to. Well, I mean,
I guess it's kind of both.
You need to assess first whether there's a high risk involved or not, and then you identify these risks more properly, whether with data protection impact assessment, to see if you can mitigate risks or not. And if you can't mitigate these risks, then and they still remain high risk even after you've gone through the whole process of identifying them and trying to mitigate them, then you need to talk to your local data protection authority and ask them essentially, hey, what are we going to do? Because you're not supposed to, basically not allowed to process high risk data in the sense that unless then you get some kind of confirmation or approval from the DPA so that they're aware of what's happening.
And so essentially that was starting to happen here. The consultations were going on in 2023 and 2024. But at some point in May, Twitter decided to just start processing the data. And as far as it looks to us, based on these open proceedings before the Irish High Court, they did so without informing the DPC. So that is, I mean, that's pretty serious. That's essentially contravening what these consultations are supposed to do. In addition, at some point, the DPC said, you need to have mitigation measures in place. To us, it appears that the mitigation measures were these, the ability to opt out of the default permission setting. So this is a setting that's about 6 steps into logging into your Twitter profile. If you go into your privacy settings, you go a couple steps in, you will eventually find this default permission to share the data. But this wasn't even existing on the platform until 2 months after the processing began. So there's some real questions here about the consulting with the DPC. Is this, how can we ensure that these kinds of consultations are happening efficaciously and with proper effect?
Well, they're not.
Apparently.
That's I can assure you from experience that the consultations are not happening. And I mean, in Sweden, we had this problem in the past that even if a controller wanted to consult with the IMY, unless it was a completely fresh data processing operation. So instead something that, okay, well, we realize that this is a high risk now, we should probably do an impact assessment on this processing that we're already doing. The IMY in the past has said, well, actually, since you already started the processing, the consultation mechanism is not something that we need to adhere to. So they simply rejected consultation requests for data processing operations that had already, begun. So ironically, you could sort of skirt around the rules by simply breaking them.
Which is what's happened here. Yeah. And I mean, that's really, it's an issue because this is a serious type of processing that's happening. What you're really looking at is 60 million users plus in the EU on Twitter. All of their data has just gone into training AI. It can't be reversed. The data that's in there can't be corrected. The data that's in there can't be accessed. You're talking about an inability for data subjects to even exercise rights over this data that without their consent and without telling them in advance has happened already. This is pretty serious. If you can just circumvent and conduct this kind of behavior, again, asking for forgiveness rather than permission, we could have some really serious infringements moving forward.
I mean, that's just the law, though. Who cares about the law? I mean, what's the problem?
Well,
the problem can't be that they're breaking the law. I mean, it needs to be something else.
I mean, the law is also securing your rights as a data subject. And these are rights that are not just based on the GDPR, they're in the charter. These are fundamental rights that we have to protect our data online and to be able to access and correct that data. This is not just in the GDPR, this is in the charter. So it's really going at something integral. The goal of the law here is to guide and ensure that enforcement and protection of data subjects' rights.
Yeah. I mean, sure, I agree with that. I agree with that. I'm just trying to play the devil's advocate because this is the kind of argument, that people tend to have when they don't really when they don't have a feeling for why this is a problem. But the thing is, data protection is really about a risk that we don't know. It's kind of like COVID in the beginning. That in the beginning, when it first came, everyone was really quite afraid of it because we didn't know what was going to happen with it. And after a while, we were sort of figuring out what COVID does to you, and we're less afraid of it, and the virus is getting weaker. But when it comes to this harvesting of massive amounts of data, we don't really know what risks are involved with it or what can happen with it, what it can be used for in the end. And that's kind of also the scary thing about AI, that it's such new, relatively, technology.
Well, there is a question in the chat box.
That's a good question, Patrick. I will rephrase it in English for Lorea. So the question here is if you can if the GDPR is dispositive in any way, and if you can basically use, I guess you would say, if you could use a contract as a legal basis to basically allow AI to process data in the way it does. I would say no, generally speaking, because what happens when you access one of these large online platforms is that I'm entering into a contract with the provider of the large online platform, and that large online platform has an obligation under the contract to provide me with space on the online platform to do whatever I want on that space, or within the limits of what the online platform can provide. So if you say that, oh well, also contracts here, part of it is you're gonna sell your data to us so that we can harvest it and use it for whatever. And
well, it's not necessary to provide the service.
Yeah,
the key aspect there. And
so under the GDPR, it wouldn't fall under the legal basis of contracts because it's not necessary to provide a service. You could say that it might be in the legitimate interest potentially under certain circumstances, because well, maybe we need to have some data from you to be able to run this thing and maybe maintain it or whatever, so that we can make money off of it. And I think to an extent you can probably use your personal data as a tradable commodity, even though there are voices in the EDPB that say that you can't. But I think it's more about selling your rights, because your rights are inalienable most of the time. They are simply, given to us by the charter or whatever, and you can't really sell your rights.
Yeah, I mean, also, I think part of the question that comes in here too is this is a new service that's separate from the reason that you're using the platform. And with X, this is particularly evident because if you even want to use Grok AI, you need to create a different type of account. You're paying for a premium service. So inevitably, It's not necessary to provide the service of Twitter, which is using a social media platform, to then train this new feature, this new technology unrelated to that service and AI. And this is something that comes up a little bit. So that's the question with necessity of contract. It's not necessary to offer the service that you are giving to the user. This comes up a little bit in our arguments with legitimate interest, where we're saying there's not really a reasonable expectation for the user that in using a platform, their conduct, every single thing that they're doing, all of their user engagement is going to be used to create an entirely new service or function or technology that is unrelated to the platform that you signed up for. Those are kind of other questions. But for contract, I think that it would be a much clearer case where it's not necessary to provide the service that the person is signing up for. And contract is a pretty strict legal basis in that regard.
If you consider a consumer rights angle instead, I mean, you could say that, you know, what's happening here is that me as a consumer, I bought a product or I like signed up for a product or something like that. And under a certain pretense, what this product is supposed to deliver. And then a few years later, the contract changes without informing me, and they start doing other stuff with my information. Suddenly it's not the same products that I bought anymore. And the question then is, you know, can I, as a consumer, be bound by this new deal? And I would say that generally speaking, in consumer law, you can't. But I mean, this is the problem with these online platforms, that they basically tell you like accept it or get the fuck out. You know. Sorry, I guess I'm not supposed to swear online, but so I think. I don't think it would fly under normal consumer rights legislation either, or consumer like contract legislation. Okay, cool. Do we have any more issues or questions about Grok AI or
/ anything by XAI
or anything?
Any AI ostensibly. Yeah.
If we have...
Well, in that case, I have a question.
Yes, shoot.
Anything to do with AIs. In your view, what's the worst thing about AIs from a privacy point of view or a GDPR point of view? And secondly, what's the best thing with AIs? And not just related to GDPR.
I think that the answer is the same for those questions.
Okay,
the possibilities
let's hear it.
Yeah.
Are...
Sorry?
Huh? The possibilities of AI is
the
answer to both of those questions.
Yeah, and it is the answer to both of them, because in terms of the cons that we're looking at, I think there would be, so one of the arguments that we make in the complaint is that there isn't a specified purpose, which is required under the GDPR, under the principles 5.1b. There is no specified purpose. Instead, they say we can train artificial intelligence, we can train machine learning models and artificial intelligence for any purpose laid out in the privacy policy. These are extremely broad purposes. So you're looking at potentially any kind of AI. This could be an AI that does face tracking technology, as we've seen before with things like Clearview AI, using the pictures on a social media platform, or anything like that. The thing is that there's no limitation. So when we're looking at an online platform saying that they're going to train an AI using your data, we want to know more. What is that AI? What is the purpose of that AI? What is that AI trying to do? Because yeah, the possibilities are theoretically endless.
Yeah, and that's also what's so nice, like what's so great about it, right?
So much potential.
Yeah, so much potential. I mean, we don't know where the technology really ends. We are approaching a situation where you have AI art that's almost indistinguishable from photographs nowadays. I mean, I saw a picture the other day, and the only reason that the woman in the picture didn't look like a human being is because she was too attracted.
Oh.
It's like too perfect, you know. So it's very possible that in a few years, you know, we will have. I mean, AI will probably be more useful to. I mean, I think thing is, I'm struggling with my thoughts because I don't really like it. Because I like things that are made, you know, handmade stuff is always a little bit nicer than stuff that's, you know, just manufactured. And the problem with AI, I think, is that it's basically just manufactured stuff. There's no soul in things that have been created by AI. But I think for a lot of people, that doesn't matter. And using it as a tool to create like marketing stuff or whatever, where you don't really need to think about things, or academic texts. It's very popular nowadays for people who don't write in their profession or in their academic discipline. It can be useful to like string text together and stuff like that. Just the way it works now. I mean, the problem again is that it removes all personality and soul from whatever it creates, which might be a question of time and practice of the AI, but
And what they train on, aka all of our data.
I mean, that's the problem. I think just the vast amount of data, and you create an aggregate of that, and it becomes the most generic thing ever, right? So that's kind of the point.
Yeah.
but it's I mean, some of you know that I have a blog that I write on very rarely, and like I've tried using AI at times to help me write texts, and it 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 doesn't work. If you want to try to sound, you know, creative or genuine, or if you want to bring out yourself, right? At least not right now, but it might in the future, and that might be something scary and interesting.
And I guess I'll close that thought by saying, because AI has endless possibilities, we would love to look at the possibility of it complying with the law.
Lorea is what we call a legal positivist, which is not what I am. So this is a fundamental philosophical difference.
I should make it broader, complying with data subject rights.
That's
not just the law.
That's fine. Okay, well, let's move on and talk a little bit about what the actual topic is, what's supposed to be today, which is about the duty to investigate and enforce complaints. So, as some of you might know, we have also had an appeal for a Swedish court in Stockholm's förvaltningsrätt regarding the IMY's duty to investigate complaints. And I want to give a little bit of context to this appeal and how it works. And just because in this particular case, it was the region Uppsala were recording phone calls when you call them to their customer service for mass transit, right? So UL, right? They're recording phone calls when you call their customer service. There's no opt-out, there's no opt-in. It's just, hey, we're going to record your phone calls for training purposes and quality assurance stuff. And when you ask them, hello, I mean, what, do you listen to all of the calls? The person on the other end of the phone, because I was the one who made the complaint initially, told me she just doesn't know, right? She hopes that she's going to get to listen to it later. When I asked them later why they're doing this, they told me that they're processing data and these complaints or in these phone calls to handle complaints and stuff like that come in through the phone line, and that's why they have to record everything. doesn't make sense because, you know, I wasn't complaining about anything. I just wanted to know what was happening with the data breach that they had informed us about. And then subsequently, they told me that it's for processing, well, to adhere to their obligation to provide mass transit, like buses and trains in the region, which I just don't understand how that's relevant when it comes to recording telephone calls. But you know, so that's the background. So I complained about this, and the IMY sent an information letter to the region saying that, okay, hey, hello, this is the law. We're not going to do anything. Done, right? I mean, you could consider this, you know, a little like a minor issue that they're like recording phone calls. Everyone does it, whatever, who cares? I mean, I would like the region to know what they're doing and why, and be able to motivate their processing because they are, you know, a public authority and pretty big, and like having people's phone calls, especially now with AI technology, is a risk. You know, because identity theft and stuff like that is not in what's it called? Like I can't pronounce that word.
Negligible.
Thank you. Risk anymore. So I mean, it makes sense to only process that kind of data when it's actually necessary. The thing is that this isn't something that IMY does just when it's you know, regions or minor things like this. It's also for major companies that clearly have problems with you know, adhering to data subject rights. So, for example, I have two complaints here, or actually decisions from the IMY that we can compare here. So this is my decision. I've complained at the region, and they concluded that they're going to finish off the complaint by sending an information letter, right? Okay, great. Done. So the Region Uppsala, you can, oh, well, you know, it's the region. I'm sure they want to follow the rules. It's, you know, it's all good. We have to trust our public authorities, whatever. But then you compare it to this other one, which is Tele2. And I want to remind you guys that Tele2 has had very poor reputation when it comes to being a nice and friendly company in regards to its customers, stuff like that. So this is a different decision, as you see, made by a different person. But here you see it's Tele2, and it is exactly the same. So it doesn't matter who receives the complaint, is what we can deduce from this. So the question is, okay, does it matter what the nature of the complaint was in regards to how the IMY is dealing with them? And I would argue, based on the information I have here, that it doesn't really. I was complaining about the legal basis. There was no legal basis for what they were doing. They need to have, you know, an actual reason to process this kind of data. It can be the region has 100,000 people living there, so lots of people. There are potential data subjects. Here you have a complaint that was ostensibly about access rights and how the Tele2 company were not adhering to basic access rights by making the process extremely difficult and not providing access actually, but sending information to a different address and everything. And Tele2 is a huge company. They had, I think they had a revenue of like 28 billion crowns or something like that last year. which is, you know, almost 3 billion euros for those people who don't know what a crown is worth.
Thank you.
Absolutely. So, but you can see here that like what they do is they just send an information letter. They started with that they haven't actually taken a stance in any way, and doesn't really matter apparently what the complaint is about. They still finish it off in this sense that they're not going to do anything. So it seems to me, based on what I've seen here, that they don't actually process these complaints in a way that leads to any kind of investigation about what's happening. And it doesn't seem to matter whether it's a private company, whether it's a municipality, whether it's a question about data subject rights, or whether it's a question about illegal processing. So, I mean, both of these cases were pretty clear in the information. I'm not going to share all of the documents because that's too much text. But they're pretty clear in the reasoning why this is why the controller or the alleged controller, because the IMY do not actually make an assessment regarding who the controller is, about the potential infringements that they're doing. So it's very easy for the IMY to actually investigate these complaints, but they simply do not. And also an interesting aspect was that in the second complaint, the one against the Tele2 company, the data subject in question contacted the data protection officer and asked for help. And the data protection officer essentially acted as like a gatekeeper. So, or like a corporate lawyer. So protecting the rights of the company instead of the rights of the data subject, essentially saying that, well, I mean, we've done everything according to the book, even though it was very clear that, you know, they were not following the rules when it comes to providing access.
Is that something you see with a lot of DPOs?
Oh yeah, this is a very common problem. I think I think there's a two-pronged reason for this issue. One is that we have like an old guard of data protection officers that used to be data protection lawyers or like corporate lawyers, and they added the GDPR to their portfolio. So they're like kind of stuck in the corporate lawyer way of thinking. So, and the corporate lawyer always protects the client, right? The problem is, or actually a lawyer always protects the interest of the client, I should say. But the problem is that the client of a data protection officer is not the controller, but rather the data subject. And this hasn't really translated well for a lot of old school corporate lawyers. So that's one of the issues. Another one is that if you do try to do your job properly, you suffer reprisals as a data protection officer fairly commonly. I think I've lost at least one, maybe two jobs as a data protection officer by, you know, trying to do my job properly. So it happens. And I mean, you need to have solid like a extremely, you can't be risk averse, let's put it like that, in today's
what you're referring to now is, well, it's unfortunately not just you. I spoke less than a week ago with a person I know who's been working as a data protection officer. And when they got a new CEO, the new CEO started interfering with the DPO's mission. So they basically stated that, well, your job and we don't need a data protection officer now, so you're redundant, bye-bye. And what he's done is he's informed the board, and he was also informed IMY that this is going on. But it's kind of interesting that companies don't take this seriously. Another question, though, is that I've been reading the new EU laws in minute detail. And it seems to me, now I haven't really done a proper comparison, but it seems to me that, for example, if you read the text of the Cyber Resilience Act, which is making its way through the EU to finally become law, when you read that text, it seems to me that they've added or improved the text to more, well, how shall we put this? To be more specific and more straightforward, that each country needs to really make a proper job of enforcing the law. Might it be the case that the GDPR is currently stated in a few things as far as that is concerned, and that the EU has upped its way of making laws to make the enforcement clauses more stringent and more well improved, in order to make each country, to force them to actually apply sufficient resources and do a proper job?
Maybe.
Have you looked into the text of the GDPR and the new laws and so on, and
no,
looked at this?
and I haven't compared it in detail, but the Cyber Resilience Act isn't necessarily about individual rights, right?
No. It's something that's a completely different thing.
Yeah, right. So,
but
it's
here, to do with proper secure software. There are some references to the GDPR in the Act, but not a lot. But the main thing is that it seems to me that they've added text specifying in more,
but let's
call it improved text to really make each country apply and, well, get sufficient resources and do a proper job.
It's possible, but the thing and the problem, I should say, when it comes to enforcement and the GDPR is that in the GDPR it's the individual versus the capital, right? Or the individual versus the state. And as we know, staten och kapitalet, de sitter i samma båt. And then we have this conflict not between money and the state, but rather against someone with no resources and everyone that has a lot of resources. And the problem here is that since the capital and the state is in cahoots with each other, essentially, there's no real incentive to give people rights other than, that people should have rights. So the enforcement here suffers because there's no real reason for the government or for the capital to actually do something about it. Whereas when it comes to cyber resilience and stuff like that, then you have a matter of national security, rather. So we're talking about functional institutions. We're talking about an outside threat focusing on our institutions. And now we're saying, okay, well, we're not protecting ourselves. We're not doing stuff to help individuals, because who cares about individuals? We're doing this to protect ourselves against Russia, which is a different narrative, and it's a stronger incentive to national institutions to do something about this issue. So as I see that as the main difference between these two.
May I ask
Could very well be.
I haven't read the Cyber Resilience Act in detail. Could I ask a procedural question? Is the enforcement a one-stop shop type of enforcement, or is it really much more delegated to each member state individually?
Basically each member state, but obviously a cooperation on EU level.
Mhm. Because I mean, that is one of the big issues with the GDPR is on the procedural level, the one-stop shop results in a kind of forum shopping situation where a lot of big tech companies are established in Ireland and other member states have a limited ability to enforce against a company that's established in Ireland. It ends up going to the DPC. We see a huge backlog of cases. And limited enforcement in that ground. And member state DPAs can still do things, to be sure, but a lot of them end up forwarding the case immediately to the DPC. So then, in addition to the incentives issue that you're talking about, there could also be a big procedural difference there on how enforcement is carried out.
Could be.
Yeah. We should talk more about this DPO thing next month. I think that could be a good topic for next month's GDPR talk. I think we already mentioned that we're going to talk about that next month. But anyway, so this thing about investigating complaints. So it's very clear from the EU, well, what's called like the EU Court of Justice. I think that's what they're called, right? EU Court of Justice. Mm-hmm. Yeah. That Court of Justice of the EU. Yes, that's the one. That the data protection authorities have to investigate complaints. It has been stated in Schrems 2. It's been stated in Schufa, and now there's another one coming which builds upon this. And I want to just share this new case with you. It's called. It is called we'll copy this. Can I copy this? I should be able to copy this. You can just copy the whole thing. So yeah, that's a good one. Here. No, that's not right keyboard. This is right keyboard. So if you go to this one, this link, you should be able to see the case. It's called C768/21 or Landhessen, which is in the currently there's no decision. It's just an opinion of the general advocate. So it's a suggested reasoning that's going to be the grounds for the decision, probably, or at least parts of it is going to be grounds for the decision. And this is the same general advocate who had opinions were laid the basis of the Schufa case, and so he's building on his own reasoning in this new case, and he's essentially saying that yes, duty to investigate, and then when you have found an infringement, they have to do something about it, and that's the gist of it. And then there are some issues here when it comes to, well, not issues, but some outliers. For example, when during the course of an investigation, the controller changes and actually starts adhering to the law, then there is no need for punitive measures or corrective measures, because we have to consider that there are two different types of measures of the GDPR when it comes to corrective measures. There's punishment, which is the administrative fines, and he says that these have a criminal law character, right? Which is a very interesting take, I think, on how we should think about the GDPR and enforcement, that we are essentially talking about an institution that is akin to the police, right? with what they're doing. And well, you know, when you report a crime to the police, you expect them to investigate if you can identify one, A, the culprit, and two, what's happened, you know. So if Lorea hits me, you know, which she usually doesn't, but if she would, then I should be able to go to the police and say, hey, Lorea hit me, and they should come talk to her and see if that's actually true.
This is all alleged.
Alleged, absolutely. Yeah, she hasn't hit me, but if she would, that is what I should be able to expect from the police, right? So what he's saying essentially is that what you should be able to expect from the Data Protection Authority as well, which is very simple, very easy reasoning, honestly. But when it comes to the corrective other measures, then what he's saying is that the point with these measures isn't to punish someone, but rather to bring the data processing in line with the law. So they can either be to change the data processing or to stop the data processing. That is essentially what the function of these other corrective measures are. So if the data controller has already either stopped the processing or changed the processing so that they are in line with the law, there is no reason for these corrective measures. And I think that the reasoning in this case is quite good, and because of lack of time, we're not going to go into detail, but you have it here, and I will. So you can all just read it. I think this link is in Swedish as well. So always happy to answer questions. So if you want to discuss it, you can always get back to me.
And if you don't feel like reading the whole thing, NOYB has a GDPR hub, which summarizes a ton of decisions. We have thousands upon thousands of decisions in there, summarizes the reasoning, and then of course links to the decisions themselves. It also provides translations of decisions from across different member states into English, so you can read what other member states are doing. But I think we have a
GDPR hub plug.
Little GDPR hub plug. If you don't feel like reading the entire land testing case, you can get some details there.
I think it's been summarized on the GDPR hub as well. So if you just type in the C number into Google and type in GDPR hub, you can probably read a summary there as well. I haven't read the summary because I am arrogant, so I don't trust other people's summaries. But I think it's probably fine. Yeah. Did you write it?
No.
No? Okay, no, fine. And finally, I would like to round off that this problem that we're seeing with Sweden with the IMY not really doing its job properly, it's not really just a Swedish problem. The thing is, we're kind of lucky in Sweden that we have institutions that are so transparent that they actually tell us that they're not doing anything. Whereas in other countries, if you look at the statistics, for example, from Finland, you have information about cases, but not what the cases are. So they don't. If you look at their what's it called, like yearly report from 2022, because I think that's the most recent one. It doesn't actually say how many complaints they've received, only how many cases in general they received. And I don't know what to make of that information. I don't know how many cases they are processing. I don't know how many complaints actually lead to enforcement. I don't know anything because I can't deduce that from the statistics that they show. In Norway, recently they've had I think it was a newspaper article where they stated that they had the exact same problem as we did in Sweden before, where their equivalent of the IMY, the Data Protection Authority, Dataföreningen, did not allow people to appeal decisions not to investigate complaints. So this isn't purely a Swedish problem. And I think that they said like about 300 or something complaints last year had that issue. So it's like, hey, we're not going to do anything. You can't appeal that. Which is, in direct conflict with the GDPR, of the text of the GDPR even, which is also something that was a NOYB action, but before my time, to change this stuff in Sweden. Denmark, similar situation. They have a fair amount of complaints. Most of them don't lead to a decision. Most of them don't lead to investigation. Most of them don't lead to, enforcement.
Something like 0.1% of Irish DPC cases lead to a decision. They handled something like 10,000 last year. We only got something like 10 decisions out of that. So, and you really don't know how the rest of them are handled, what happens there. This is a really big issue.
The statistics in Sweden was like 5% the last couple of years. So we're winning, at least when it comes to Ireland. Well, but there are some data protection authorities seem to be doing a little bit of a better job. So, we usually, if you look at the enforcement tracker, you can usually, it looks like Spain and Italy is ahead of the curve. But my point is that this isn't something we're doing in Sweden just because it's a problem in Sweden. This is something we're doing in Sweden because the Swedish courts can help bring everything up in the rest of Europe as well by clarifying what the duty to investigate is when people don't follow the law.
Okay. And on that note, I guess I should say that it's 1 minute past 1 o'clock. So the official part of this meeting today is over. If we have any questions or comments, etc., we are, of course, well, I don't think we should stop this meeting right now. We could go on for a few minutes more. So my question is, do we have some questions or comments?
Vi kan alltid ta det på svenska om det underlättar.
Ja, just det.
Ja, och som sagt, det är helg här. Så jag har all tid i världen. Och slut på kaffe.
Okay. I think I should do a few things. First of all, I think NOYB is doing a great job. You guys don't know it, but that's not a new idea because I've been a supporting member of NOYB since 2018.
Oh my gosh, that's so nice.
I am not a supporting member of NOYB. And I am not a supporting member of NOYB. Maybe I should be.
No, I am. And the reason for that is I think you're doing a really, really, really useful job to help all of the rest of us. So you guys who are online right now, if you want to support NOYB as well, by all means, it's easy to do so. Because the Schrems decisions and quite a lot of other things really do great work for the EU community.
That's the idea.
So
thank you and keep up the good work.
Yeah, thank you for being a supporting member, because I should note, like, that NOYB's something I admire. I'm a trainee. My traineeship is tragically coming to an end very soon. But something that I really admire about NOYB is it's very distinct from other NGOs where the vast majority of its funding is from supporting members, and it is representing the interests of those members. It's trying to help data subjects across the EU. And it gives us a lot of freedom to take on the cases that we think matter to people in the EU, as opposed to being bound because we're receiving money from certain entities or something. So it is, these memberships are what keeps NOYB going. And we're very grateful for that.
Yeah. And on that topic, I guess we should, wrap this meeting up. In a month's time, in other words, the third Thursday of next month, we'll meet again and talk a bit more about GDPR. Next week is
perhaps
another
more personal story then.
Sorry.
Perhaps with a more personal story about what it's like to work as a data protection officer.
Yeah.
Yeah, hopefully.
And I think that is going to be an interesting story.
I think so too.
I know about the story, and it's quite interesting as far as I see it. Next week is not GDPR, but it is the CRA law and the NIS2 directive. And until then, well, thank you for today, and bye. Be seeing each other.
Thank you for having me. It was great to talk to you all.
Oh, you're welcome back.
Thank you.
She won't be.
Bye.
She won't. Maybe from somewhere else, but not
Yeah.
from this office.
Yeah.
Sadly, I'm happy
Okay.
you got to meet Lorea.
Bye-bye.
See each other next week or next month. Bye bye.